Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime and we are here to snark at Stephan Stearns, who's made even more demands. He's made a lot of demands leading up to his first trial, which is where he's facing 60 counts of child SA material related charges for having 1,700 images and or videos on his Google account of the victim, Madeline Soto, which you can see pictured over here. And this is just the first trial, right? So the accusations are that he was sexually abusing her from when she was around 8 years old. Now, she had just turned 13 in February of 2024 when Stephan Stearns is also accused of murdering her. Okay, so that'll be a whole separate trial. That trial is supposed to start in September. As we know with these things, sometimes trials get delayed, like this one has been delayed several times. Now, today's date, if you're watching live with me, is July 14th of 2025. And so it's really just around the corner that his trial is supposed to start, which is July 22nd of 2025 with jury selection. From everything I'm hearing so far, it seems like it might actually be streamed. They obviously cannot show, and they better not slip up and show any of the content that they're going to be showing. You know, the images and the video, shame. Oh my goodness, imagine the jury. They're going to be showing that to the jury. The trial is expected to last about 4 days or so, you know, so it's going to be any minute now. We'll be ready for it, and if they're streaming it, we are absolutely watching it together, right? Gerda says, perfect stream for 2-year-old tantrums. Happy Grizzlyversary. Gerda, thank you for 2 years of support. So let's first, wait, I just want to boost the sound for you so we can do that, because wow, this courtroom audio is absolutely terrible. I hope they fix that if they are streaming the trial. So before the trial, let's hope that they realize that this courtroom audio sucks. Okay, they need to improve it a bit. So we're boosting it. No matter what, we'll always just boost it or whatever, right? To make sure we can hear. Here he is. Here's Stephan Stearns walking into the courtroom like a friggin' baby boy that he always is, just always the victim, the perpetual victim, being like, you know what, I don't want to have any restraints, and I would like to use normal writing instruments. That's what this motion is. This dude is using the court's time to ask the judge to allow him to use a real pen. He wants to use a real pen, and he doesn't want to be shackled, okay? Why would they restrain him? Because you're accused of SAing a child for many years and murdering her? You're a dangerous dude. Unhinged. Anyway, so he's facing the death penalty as well, which especially for the second trial. If he is convicted, which I absolutely believe he will be, and he's very, very dumb to take this to trial. If he's convicted in this trial coming up, yeah, it's going to be an aggravating factor apparently in the next trial for the death penalty. So he told his parents on jail calls that he rather wants to be on death row because he thinks he'll be safer. But somebody needs to tell him, okay, relay this message that, dude, you're not going to get root beer barrels or commissary if you're on death row. If you go LWOP, okay, Gen Pop, yeah, you could still get commissary from your parents. They just need to tell him that. Books, commissary, yeah, go there. Plead guilty, do the right thing. Do not put people through this because it's going to traumatize so many people. Even more, right? Okay, so let's have a listen to this hearing. It was almost an hour long, not even, it was 44 minutes or so. So here he is walking into the courtroom today. Shackled, as you can hear.
We're on 3 preliminary trial matters. These hearings are scheduled for 1 hour. Ms. Smith, I don't have a preference on what order we handle your motions. Would you like to address first? Question. Mr. Johnson, my apologies.
No problem. Tagging on the first motion, Alex Johnson for the defense. We'd like to address defendant's motion to remove newspapers from courthouse during pendency proceedings.
All right, thank you.
As to argument for this motion, defense did have pre-marked this morning, and I would it's been pre-marked today. And a copy of the Osceola News Gazette that was present in the lobby this morning, which directly addresses the Stephan Stearns trial to begin July 22nd on the front page of the newspaper of the Poll.
State has no position, Your Honor.
Thanks. We received a defense one for purposes of this hearing.
Joey Mathieson says in Afrikaans, 'n regte slapgat. Yeah.
As to this motion,
A lazy, stinky baby boy. Okay, YouTube, I'm not snarking too hard. This is based on evidence. There's jail records that say that he refuses showers all the time. All the time. He hardly ever showers. He has a haircut like once a year. He's looking quite rough here in the courtroom as well. And I feel sorry for people sitting next to him.
with the recent denial of the motion to continue, the trial is set to begin next week in this courtroom. And as jurors, potential jurors and jurors that are selected in the trial walk into the courthouse, right in front of security or right beyond security is a slew of newspapers, including newspapers like the Osceola News Gazette, which every time we've had court appearance, Stephan Stearns has appeared on the front page of the newspaper. And the newspapers constantly indicate that there's both a sex case that is currently pending, which is what we're here for this morning, as well as a capital murder case that is pending. So defense is requesting that just during the pendency of the trial, not ongoing standing order going forward, that we remove these papers so that way the jurors are potentially as they come in and go about the courthouse.
All right, the state takes no position.
They don't want the jury to be snarky. Obviously, they have to, not know about the case, but to see any newspapers with his ugly mug on it saying that this is what's happening. That makes sense. No newspapers, no pictures of him, none of that. Okay. Yeah. Do you think he'll plead guilty before this trial starts, or do you think that he's literally going to take this to trial? I think he's the type that's probably going to take it to trial. He'll take his chances,
I have confirmed with jury services that jury services do not provide newspapers to potential jurors. Court always has to be careful balancing the right to free press and the right to open and fair jury trials. I do find that should there be newspapers available where the jurors, can you give me some guidance as to where this table is downstairs? Is it over by the employee area? Is it where the general public would come in?
It's where the general public comes in. It's so if you're looking at the first floor, there's the area where you go to the elevators, and then there's the mirror there.
Yes.
It's the table's right in front of that.
Under
Security.
the progress screens.
Yeah, exactly.
I have inquired as to our court administration who provides the newspapers. I think that's a county function. We have proactively reached out to the county to see if we could suspend the delivery of newspapers during the jury selection process and throughout the trial. So your motion is preliminarily granted. The court will direct the parties that provide the newspapers not to do so during the jury selection or trial process.
Thank you.
Smith?
Yes, Judge. Defense would next like to proceed on the defense's motion to order all media to adhere to the rules of judicial administration and administrative order. Essentially, Judge, defense is asking, according to, as the rules require, that the media, and since defense is on the left side of this courtroom and the media is positioned directly behind us, their cameras, intentionally, inadvertently, I'm not saying that they're doing it intentionally, it's focused on counsel's table in order to get views of Mr. Stearns and things of that nature. So in positioning, counsel's computer screens are in view of the media, so defense is requesting that the media not be allowed to look at, zoom in on, or otherwise project essentially onto counsel's table because of work product and attorney-client confidentiality. I understand that attorney-client confidentiality, we have to essentially affirmatively attempt to protect it. And when we have communications, we do mute the mic. However, because the table is so large and spacing, it's just asking the media not be ordered, not be allowed to zoom in on our computers or our computer screens. Under the administrative order, it says that communications between attorneys and their clients, between counsel and co-counsel, or anything that's held at the bench is required not to be recorded or broadcasted. So the defense's position that anything that is occurring essentially at counsel's table in terms of notes, whether that be handwritten notes or computer screen notes, not be looked at. The defense has taken affirmative steps to have a privacy screen and additionally dimming the lighting on the laptops. However, even with that, it still is doable for the media, and sitting in court with dim.
Well, you can get screen protectors that prevent, people from seeing, if the camera's from behind like this, right? But okay, no zooming in on what they're writing, scribbling, saying on their laptops there.
Screens and dark lights for multiple hours is going to cause headaches, but also to protect not only Mr. Stern's confidentiality, but potential other clients' information who we're working on while here in court with the media not being allowed to look at and zoom in on computers or counsel's computers.
Your Honor, the state doesn't have a position. However, I think if the court is going to issue an order, it needs to be to everybody in the courtroom, not just specifically media personnel.
Are you saying to the state as well, in terms of media personnel, or anyone not being able to do it?
There's a lot of amateur media people that will cover this trial, and they use phones, from my experience in other high-profile trials. So the order should be broad enough that it covers everybody in the courtroom, perhaps even an order that people in the gallery should not be allowed to have their phones out during the trial. Yeah. Sometimes they need daily reminders, sometimes they need multiple daily reminders, but they also focus on the state's computer, and we are obviously against that for the same reasons.
And there's no objection to the line of the motion.
All right, our relationship with the media has been a good one. They are an essential community partner, and as I said, the court's going to strive to ensure that this is both an open trial and a fair trial. The days of passing notes back and forth are behind us. A little experience working with each of the attorneys here. I know that your coordination with witnesses, with each other, with presentation, with evidence is highly computerized. The court will expect that the media will comply with Florida Rule of Judicial Administration 2.450, as well as our Administrative Order 2023-23. That order is fairly specific under subsection 2E, indicates that representatives may not cover sidebar, bench conferences, no recordings of conferences or information that occurs between attorneys and their clients, between co-counsel, between counsel and the presiding judge of the bench. I've done several trials where the media was involved. The only violations of 2.450 in our administrative order, in my opinion, have been inadvertent. Those inadvertent issues were when a camera operator perhaps went to a wide shot that included faces of the jurors during the trial, or there was a microphone that was inadvertently picking up communications through the microphones at the counsel table after the microphones had been apparently muted by the attorneys. These are technical issues. We have a technical team here that the media is absolutely welcome to coordinate with. The administrative rule gives the media an opportunity to meet with our court administration if they have any questions about what the court's expectations will be. The court will expect that the media representatives will be credentialed pursuant to the rule. Non-credentialed members will not be permitted to have out cell phones as members of the general public. So I see no issue with the defense's request to have the media comply with the rules that are already in place, and the motion is granted. If representatives of the media have specific questions, they may contact my office. I will direct them to our court administration personnel.
Thank you, Florida, for having cameras in the courtroom, right? Stephan says, then, would you mind to would you mind to get some more cameras in the courtroom, Judge? Thank you. I also vote for lapel mics or any mics that are better than this. Just great audio would be amazing. Thank you so much.
Provide a copy of the administrative rule, which I'm sure they are most familiar, and judicial rule, floor rule, of judicial administration. So the court will expect that that will be scrupulously followed in an effort not to impede the fairness of these proceedings.
And then the last one is physical restraint or utilization of normal work.
Thank you. State, you anticipate presenting any witnesses in support of restraints?
The state just has one.
All right, thank you. And then,
Deputy Richard Grizzly.
thank you.
Okay, so they're going to have, the state has one witness testifying today. The defense's motions are that Stephan Stearns would like to be shackle free and that he would like to use a normal, a normal pen. Not crayons, okay? A normal pen, all right, for this trial. So from everything that I'm reading from all the media reports so far, what they're saying is that the trial is going to be streamed, which means next week we're watching it together. I will so be streaming this, okay? As long as there's cameras in the courtroom and it's live and all of that. But let's also see what happens on day one. Will he plead guilty then? Huh? Or you still gonna carry on with this, dude? Oh my word. Is it Doctor TPA? Thank you so much for your sticker.
Solemnly swear or
You do?
Look, he's not wearing the little t-shirt that his mom and dad sent him today. Maybe because we pointed it out last time, I'm not sure. But he had like a white shirt underneath, which is not usually jail issued. And from his jail records, which I get regularly, we've seen that he's, still getting books and things, root beer barrels, yes. Spicy, refried beans, sardines, all of that, and candy, all these favorite candy and all that. And then also boxer shorts and like shirts, long sleeve shirts, things like that. So I think last time he was wearing something under here that his parents had sent him as a gift, but now today he's not. Either because he's that dirty, didn't put that in the wash, or maybe he just doesn't want us to focus on that. Okay, because we will. All right, let's keep going.
Good morning. Will you spell your first and last name for the record?
Yes, Ricardo, R-I-C-A-R-D-O. Last name is Rosario, R-O-S-A-R-I-O.
How long have you been employed as a court deputy?
Since March of 2017.
And is your primary assignment to this courtroom that we're actually in right now?
Yes.
Are there policies in place for the use of any type of restraints during a felony criminal trial for an accused?
That's correct.
And how many felony criminal trials have you participated in as a court deputy?
Numerous countless. I can't remember how many.
That's fair.
I've worked for.
What type of devices or restraints are available that would be out of the view of members of the jury?
So each courtroom has two, one device is kept downstairs on the first floor, which is a stun cuff, and in the courtrooms we have a leg brace.
How is a leg brace utilized by court deputies during the pendency of a criminal trial?
So a leg brace is essentially a long bar. It has 4 straps, and in the center there's a tab that you can pull so the person can sit down. Otherwise, the the bar won't bend. So basically what happens is when the person said to bend, but when they stand up, it just locks and it prevents the person to run away. Well, they would have to essentially hop away because that leg is stiff.
What is the purpose? Let me ask you this. Are there any safety concerns for you as a court deputy in this courtroom should a accused during a criminal trial not be equipped with such a thing as a leg brace?
That's correct. So when any inmate is brought over to the courthouse, they're in restraints, handcuffs, and leg chains. When they're brought over for a trial, they are dressed out in proper attire, suit, and at that point, they're in the custody of the sheriff's office, and we have to maintain a level of safety and security for the inmate and as well for everybody else in the courtroom. So that's the reason why we utilize those restraints.
Is there limited staff here at the courthouse for the sheriff's office?
Yeah, so
Quick pause. So for those of you just joining now, if you missed the update from the last hearing, all the evidence from Stephan Stearns' phone is in. The judge was supposed to rule on that by June 30th, and then we heard the ruling on around, I think it was July 2nd or 3rd, something like that. Yeah, all the evidence from his phone is in. That's why this trial is going ahead, and all of that evidence will be shown to the jury. I feel so sorry for the jury. You know, in this hearing, towards the beginning there, when the defense started speaking, the defense attorney literally called us a sex case. Sir, I think you forgot the word abuse. A child sex abuse case. It's not a sex case. So just for the record, I just want to say that because that was really a mischaracterization of what is going on here, right? This is the worst of the worst, in my opinion. Like this guy, wow, sexually abusing a little girl. From the evidence shows from around when she was 8, but I'm sure things could have started from before then, right? He was in her life from when she was around 6 until she was 13, and then he's also accused of murdering her. That will be a separate trial, and we'll be watching that one together as well. If you're new here, then please know there's a playlist for you, and we've been deep diving this case since it happened, since Maddie was actually missing. I was so hoping, we were all hoping that they would find her alive and well. You know, we thought maybe she did run off into the woods or something like her mom and Stephan Stearns was saying, but sadly, no, this case became so much worse. Okay, so let me quickly answer this while I'm paused. As a matter of fact, I do think Stephan Stearns is playing the long game and he's going through trials so that he can appeal the ruling of the legality of the phone. I don't know. I think he just thinks he has a chance. You know, he's a little bit delusional in that way. If you listen to the jail calls, I think he just thinks, let me just take my chances, because why not? Why not? Because he only thinks about himself, okay? I hope there will be full justice for Madeline Soto.
in a perfect day, the felony courtroom.
Hold on. What's happening here is that the defense has filed a motion to ask that Stephan Stearns be unrestrained in this trial. Shackle-free. Stun cuff-free. Okay? So that's why this Deputy Ricardo Rosario is explaining from the state side what it is. You know, why would he need it? How does it work? All of that, so the judge would then make a decision on it. In this hearing as well, they were talking about the media coverage and these amateur media people that will probably be covering it. That's probably us, but you know, we're not amateur over here, okay? But okay, YouTubers will definitely be covering this trial. And the other thing that they argued was that Stephan Stearns wants to use a real pen, okay, to make notes at this trial. I mean, he shouldn't even be able to write, honestly. Just shackle him up.
Would have 3 deputies. A misdemeanor courtroom would have 2, and civil would have 1. But due to staffing, sometimes people take off or they're sick, and there's it creates a safety hazard if we're running a high-profile felony case with just 2 deputies. So hence the reason why we used also the device.
Is this device something that is visible to anybody that is looking at the outer appearance of an inmate that's wearing it?
No.
Is this device something that delivers a shock or pulse of electricity or anything like that?
That's correct.
It does or it does not?
It does.
It does. When does that happen?
So, if I may, I have the device in front of me.
Would utilizing the device assist you in explaining how it operates?
Yes, ma'am.
Go ahead.
So, essentially, this is a stun cuff
No, bring Stearns up and show us. Demonstrate on him.
that's wrapped around a inmate's ankle and is tucked away under the clothing. There are two metal pieces here that is close to the subject's skin, and the strap is placed accordingly and wrapped not tightly but snug so that it won't fall off. The remote is this right here, which is kept at all times with a deputy within the courtroom. Nobody.
I would like to file a motion, okay, formally, to have control of that remote, please. Could I hold that while the trial's going on?
knows who has it. It's hidden discreetly. No one sees it. To activate this cuff, it's a two-step process. There's on, and then there's fire. So the device won't accidentally fire on itself. It has to have a two-step button to fire the device.
And the device is
Well, you know, if they do give me control of it, I might just forget which button's which. I might. Okay, I can't promise that that it won't fire.
isn't triggered by movements of an individual or anything like that either.
That's correct.
And is this something that is utilized by court staff in addition to the leg brace that you described?
It's one or the other.
Okay. So there's two options that are potentially available to court deputies depending on the scenario.
Correct.
And both of these options are outside the view of anybody that is looking at the outer appearance of an individual as long as they're wearing pants.
Correct. So when we put these devices on the inmate that's scheduled for trial, it's out of the view of the public, it's out of the view of the jurors. No one knows that the person set for trial has it on.
And let's talk a little bit about writing utensils. If there is an inmate present in court, are they given a writing utensil?
Yes, they do. They get a flexible pen.
And those flexible pens are made available by court staff to individuals that are participating in the criminal trial process.
Yes.
And what is the purpose of court deputies providing that specific type of writing utensil?
Essentially, the pen, it does write well, but is used sort of for a safety purpose in the event that the inmate would like to use it sort of as a weapon. The pen is designed to fold and flex as opposed to another pen or a big pen or a metal pen that can actually be used as a more deadly device.
It's a safety concern for court deputies.
Yes.
Can I just have a moment?
Of course.
But he wants a real pen. He doesn't want a flexible pen. That's part of his motions, okay? Here's Stephan Stearns, everyone.
For the purposes of this trial next week, what is the type of restraint that court staff deemed as appropriate for this?
We will be utilizing the stun cuff, and actually this is a newer version. The older version is a much bigger, broader box. This one is a newer one, so we'll be using this one right here.
And sir, what kind of shock does it deliver if used? Do tell, do tell. I don't think they'll allow me to ask questions, right? I'll look a little too enthusiastic about it, I think.
Thank you. Defense?
Good morning, deputies.
Good morning.
Now, you talked about the number of deputy or court personnel typically kind of staffed in the courtroom. Are you aware of what arrangements, if any, have been made in terms of staffing for this trial?
None yet.
So you don't know how many deputies potentially would be or won't be in the courtroom?
That's a question above my pay grade, so I just will have to figure that one out.
Understood. Now, you talked about two different devices, and you indicated that the stun cuff is the intention in this case, correct?
Yes, ma'am.
And is that because that's generally what's used in this courtroom, or because of what?
99.99% of the time, we always use a stun cuff.
So I want to talk a little bit about the leg brace, since you did talk about that. Now, this leg brace, this is a longer device. Like it's not as small as the stun cuff, correct?
Right. It's essentially a metal bar. It's pretty long and it has 4 straps.
And to your knowledge, is that comfortable or uncomfortable?
I would say rather a bit more cumbersome because it's strapped alongside the leg of the person, and if they stretch their leg, it'll snap shut.
So essentially, normal movements could cause it to lock up.
Yeah, as soon as the person stands up, it will lock.
Can I use both on
And
him?
then the stun cuff, I know you talked about this being a smaller apparatus. That goes typically closer to the ankle, correct?
Correct.
And depending on the type of pants or clothing that is worn by the person, that could affect the visibility of the item.
Yes. So normally, male inmates will always have long pants, and the cuffs go right around it, so you really can't see it.
But the pants legs would have to be wide enough to kind of flow and fall over so it wouldn't be visible, correct?
Yes, and we always apply to the right leg, which is furthest away from the jurors.
Okay, so no skinny jeans for him for his trial.
And typically when sitting down, your pants often rise, generally speaking, correct?
Yes,
And so if the pants are shorter, then the stun cuff at that point would be visible likely?
possibly.
And those
But what if he wants to wear his flippy floppies and his khaki shorts that he wore the night, when he was trying to show the police the fake spot that he, didn't drop Madeline Soda off at? Because that was part of the defense's motions. That's shame. He hadn't even eaten. He was wearing flip-flops in the cold, cold Florida night, okay? The guy didn't give consent. Yeah, he did. We heard him give consent many times for them to check his phone, download his whole phone and everything, which is why the judge ruled all that evidence will be in for this trial.
straps, I know we saw kind of like the strap that goes around. Where does the extra, so to speak, of that tuck in, or does it tuck in somewhere?
So when you apply this apparatus, it wraps around and then the strap goes through here, so it holds it down.
So similar to a belt, you know how when you use a belt and you have the extra, where would you tuck in, or where does that extra strap go?
It just remains there and it just folds in.
So would it be secured, or would it be kind of sticking out?
Just stick it out wherever you would really have to look for it to find it.
Okay. Now, you talked about the two-step process with that remote for the stun cuff. I believe you said it was an on and a fire, correct? So does that mean that once the stun cuff is applied, it's typically automatically in that on position, and then you just have to go to step 2 or something else?
Well, the apparatus is turned on, so it's always going to be on. But to fire it, you have to press the on button again and then press fire.
Okay. And those two buttons are, I don't want to assume, are they next to each other on the remote, or are they two different areas of the remote?
Yeah, so the on, and then you would have to switch over to fire.
So one side is on and one side is fire?
Right.
And I believe you said that typically one deputy has it maybe between the three of you or two of you, depending on how many are in here, you guys would know, but none of the other court
Nobody
personnel.
knows who has it.
Just the person who has it, I assume.
Yes.
So you would know that you don't have it, and so if it's only two of you, by process of elimination, the other person would have it.
Correct. So essentially, when we do a courtroom operation, each deputy has an assignment. One is for the inmate, one is for the jurors, and one is for the security of everybody else.
Now let's talk about the writing utensil. You talked about this flex pen or the flexi pen, about how it's designed to collapse in on itself. Now this pen still does have a normal point, that a ballpoint pen would have, correct?
Right.
Would the utilization of, say, a felt pen be something that could potentially not be a safety measure?
Well, we're not really concerned about the tip of the pen. We're concerned more of the body of the pen, a more firm structure to be used as a stabbing type weapon.
Uh-huh. And with, are you familiar with felt pens? Okay. Now with those, typically that point, it's soft, correct?
Yes.
And with the flexi pens, and even with the stun cuff, those are only utilized for people who are in custody, correct?
Correct.
If an inmate who wasn't in custody was sitting at counsel table, he wouldn't have to have on, or she would not have to have on a stun cuff or a leg brace, correct?
Correct.
And writing utensil, if a person was out of custody, they also would not have to use a flexi pen, correct?
We normally give them flex pens as well.
Even a person who's out of custody?
Yes.
In terms of, I know you talked a lot about safety. Are you aware of any attempted escapes or anything like that for Mr. Stearns?
Of Mr. Stearns or any other inmate?
Mr. Stearns specifically.
No.
Can I have a moment, Judge? Have you had any defendants complain about the comfort of the stun cuff or the leg brace?
No. So essentially, if the stun cuff, we put it not too tight, so it doesn't impede with blood flow or anything, or potentially injury, but it is placed snug, so this way it won't slip out. So, but we've not had complaints.
So no one's ever complained about like itching or discomfort or rubbing?
No.
What about with the leg brace?
I've not had much use of the leg brace. So the leg brace, to be clear, is if the courthouse has a number of jury trials of that day, and these stun cuffs are placed in the chargers, respectively, downstairs in our office, and whoever gets there first just grabs them, then we just have to go to the leg brace because there's no more stun cuffs.
Okay.
But will he be comfortable? Or will he be itchy? Like these motions right before the trial. Can you imagine? They're talking about what kind of pen he's going to use. I know it's part of the process, but damn, Stearns, damn. Stop making these demands. I want to use a normal pen and I want to be unrestrained. Okay, he's checking. Am I going to be comfortable? Am I going to itch? Yeah, you probably are, just because you're you, right? Mandy said he showed no mercy for Maddie, so no mercy should be given. Suffer Stearns. Deborah, welcome. Thank you for everyone who is supporting the channel today, even just for being here. Like, share, do all those things. That's a free way to support the channel as well. Okay, here we go. We've got about 20 minutes more of this hearing or so.
Do you know how many stun cuffs the sheriff's office has in terms of within the courthouse?
Well, I believe we have 4.
And I know you mentioned staffing and things like that haven't been addressed yet, so you're not necessarily sure of the logistics of what potential other trials might be needing them.
So normally with big high-profile cases, there's a meeting with the judge, court, jury services, and sometimes our supervisors will be there just for logistics.
Okay. But I believe you had said that at this point, you're not sure if it's happened or you weren't a party to it.
Exactly. I have no knowledge of anything.
And then one more moment, Judge.
Of course.
Welcome, Farmhouse. Jean Maria says, can we have a stream for Snark Time? That's what we're doing now. We have so much snark for this guy. This man-child, this baby boy, maggot mouth, all of those things. Yeah, we're snarking it up here while we're listening to this crap that he wants. A normal pen, and to be unrestrained. He doesn't want to itch, okay? He doesn't want to be uncomfortable at this trial where he's facing 60 counts of child essay material related charges, right? 1,700 images and videos of the abuse. That's what they have. So, wow. This jury selection, as you can see from the pinned comment, if you're watching live with me, starts on July 22nd of 2025. And so he's going to annoy us because it's going to clash with Brian Koberger's sentencing on July 23rd. But don't worry, we'll watch all of it together. We'll then first watch Stearns and then Koberger and all that, okay? Don't you worry. Make sure you subscribe, notifications on so you don't miss out. Southern Calibre said, sounds like first come, first serve Stearns. You don't get first bids on anything. Exactly.
And I know you mentioned not being aware of any like escape attempts or anything like that. Are you aware of any violent outbursts or any propensity for violence that Mr. Stearns has demonstrated during the course of his incarceration?
No, he's been quite compliant with everything we tell him to do, as far as just remain seated and come this way and sit down. He's not giving us a problem yet.
It's because he doesn't have a spine, and also because, what's that guy's name? Miguel? Owns him. He's very compliant because he's got a guy that's using his the phone pen and his commissary and everything. If you missed that update, it's on the playlist. There's a YouTube short about it as well on the playlist of the case, okay? But, oh shame, he's been a very good boy in jail. I'm sure Stearns, if we could see his face there, we're like, yes, I have. I've been very compliant. Yeah, don't worry. Inmates everywhere are watching this. Yeah, probably chomping at the bit, waiting for you to be sentenced. I would assume, does anyone know, okay, maybe I'm asking a dumb question, I don't know. If, because he's innocent until proven guilty, if he gets convicted in this case, will they send him to prison and then bring him out of there for the next case? Or will they just keep him in the jail and wait for the next trial? And then if he gets convicted there, then he goes to prison. You know what I mean? Because wherever he's going, I think it's going to be hectic. I think everybody in the area will know what he did, and knowing that he's accused of sexually abusing a child for years, and then accused of murdering her. Can you imagine his time? Wherever he goes, whether it's Gen Pop or death row. Oh my word. Noto said, get some new pens for this trial. Me. Yeah, I can use all sorts of normal pens. Should I flaunt it? I really like these, by the way. Okay, let's keep listening to here and see what the judge decides as well.
No further questions, Judge.
Additional witnesses or evidence?
No.
Thank you. Defense argument?
Yes, Judge. Defense in this case is asking that Mr. Stearns be free of the as either use of the leg brace or the stun cuff, and we're also asking for the use of a regular writing cuff, specifically maybe a belt pen in this case.
Why? Why do you care what writing intensely?
Judge, in
I love that. The judge is like, why? Why do you care what writing utensil he uses? Excuse me, he has an image to uphold, okay? Shh. Doesn't want to be using a flexi pen. He doesn't want crayons. He wants a regular pen because he thinks he's a very clever little boy.
in prior experience, the flexi pens, they often skip, they often don't have ink, or they don't write well, so when a time is to communicate, especially in an attempt to not use the microphone, so it counts compared to questions that are being asked, having a utensil that writes and functions easily and freely as opposed to having to stop, well, not necessarily stop the proceedings, but trying to get a deputy's attention to get us another flex pen while we're also trying to watch what is being presented, listen for objections or making necessary objections. Essentially, it's a distraction if we're having to make sure that his pen is working, he's able to communicate with us, or being able to read it if it's skipping, so we're trying to figure out essentially what are the holes in the bubbles of what he's writing. Generally speaking, the flexi pens in the past haven't been the best. And I understand, kind of like a regular pen, you grab one out of the box, if it works good, it works good. So we're asking for like a felt tip, and I understand the deputy's testimony in terms of the safety concern. It's the defense's position that the use of a felt tip can be, and it's a soft tip, it's essentially a marker, we would give it to him
Just do ask for a box of crayons, please. You can have that, right?
without the cap would be sufficient. He would be able to write and communicate with us easily and effortlessly without having to worry about him stopping or not working and things of that nature. So we're asking for the use of a regular writing utensil, and we're proposing a felt tip pen to utilize. And then in terms of the restraints, again, we're asking for Mr. Stearns to be free of physical restraint. I understand the policy of the sheriff's office and things of that nature. However, it's supposed to be looked at as a case-by-case basis, not a general policy that applies across the board. There's been no testimony of any escape attempts, any offensive or violence during the course of incarceration. However, the deputy actually testified to the opposite, that Mr. Stearns is compliant, that he listens, follows directions, does what it is that is asked. So, and I understand the staffing issue. However, at this point, they're not aware if the number of deputies that will or won't be in the court anyways. So the defense is asking that Mr. Stearns be free of physical restraints, because if he was out of custody in this case, he would not have physical restraints.
But he is in custody. If he was out of custody, he wouldn't have physical restraints. So therefore, can he please be unrestrained? No, he's in custody for the worst charges possible. Yeah, keep him restrained. Sarcasm says, showing some love and appreciation for all your hard work, your snark, and being such an amazing advocate for victims, and maybe a little help with the FOIAs and coffee. Thank you so much. That is so sweet. And you said justice for Maddie. Yes, I really hope there will be, and I think there will be. I think the state's case is actually very strong.
Deputy testified that typically people who are out of custody also use flex pens. That hasn't generally been my experience in this courtroom, but that could have changed since the last time I've done a trial here in this courtroom. The defense is asking that Mr. Stearns be free of physical restraint and utilize regular writing
Thank you, Ms. Smith.
Yes, Your Honor, the state provided testimony through Deputy Rosario, who testified as to what type of restraint would be used for this trial should the court deny the motion, the process of utilizing that stun cuff. Also, he testified as to any potential safety concerns with this being a felony criminal trial, and also any safety concerns with the type of writing utensil provided. The state would request that the court deny the defense's motion.
Thanks. Can I see one of the safety plans? Do we have one?
Is that the flexi pen? I like this judge. Judge Keith Carstens.
All right, for purposes of the record, I'm holding one of the safety pens. They basically the internal tube that has the ink in it, and it's surrounded by a clear rubber tube, very flexible. They're also about 3 inches long. Look essentially different than the writing instruments that the attorneys would be using. All right, we're not, on the Chatham motion, we're not in uncharted territory. There's some case law that applies to this case. Weaver v. State, 894 2nd 178. It's a Supreme Court case from 2004. In that case, there was a defendant that was charged with serious crime. In the appeal, they took issue with the electronic restraining device, belt in that case. In that case, the defense cited the United States v. Durham. That's 287 Federal 3rd 1297, 11th Circuit 2002 case. In that case, the 11th Circuit indicated that a stun belt poses a greater threat to the dignity of the courtroom than shackles. That was based on a potential that it is reasonable to assume that much of a defendant's focus and attention when wearing a stun belt is occupied by anxiety over a possible triggering of the belt. Interestingly, in that case, there was an accidental discharge of the stun belt that occurred outside of the presence of the jury. The Florida Supreme Court in that case found that the judge's discretion in exercising of the discretion to wear a stun belt was warranted. However, in that case, the defendant was pro se and was permitted freedom of movement about the courtroom. So the court in the Weaver case surmised that there was no lesser alternative other than the stun belt to allow freedom of movement, as well as accomplishing the concerns, which was a concern regarding escape or proximity to the attorneys, the jury, and the court. In this case, we do have an alternative. The court has never had an accidental discharge of the stun cuff. The court has not before had any indications that the stun cuff was visible to the jury. The court before has never been presented with the argument that a defendant was preoccupied by the wearing of the stun cuff. But in this case, Mr. Stearns will not have freedom of movement in the courtroom. The use of the leg brace, the court as well has never received a complaint about the comfort of a leg brace. Because Mr. Stearns will not have freedom of movement, the court's heard no prejudice to the fair trial proceeding to have Mr. Stearns wear a leg brace that would, in the unlikely event that he not be compliant and stand up and make an effort to exit the courtroom, that would lock and give the resources that are on hand an opportunity to intervene. The court understands that these matters should be considered on a case-by-case basis. The court can see no prejudice. The device will not be visible. The court has not before received a complaint about the comfort of that particular device, and the fact that Mr. Stearns will not be permitted to move about the courtroom anyway. The court can't find that would be prejudicial, and the court finds that a consideration of due to the layout of this courtroom, proximity to the jury, proximity to the exit of the courtroom, and the severity of the allegations and the emotional nature of the surely to be presented that a leg brace is warranted and will be ordered to be implemented while he is present in the courtroom. And we also have a private area that can be outfitted, and I'll address continuing concerns moving forward.
So essentially his motion to be unrestrained is denied. Yeah, won't be able to move around the courtroom, will need the leg brace. Okay, so that's another loss for Stearns.
That is going to conclude our hearing. Use of the pen. He'll be provided with a felt pen. I'm going to ask that that be specific to Mr. Stearns. That will remain in the courtroom. When he comes and goes, he can have the flex pen in the back if he needs to write notes while we are not.
So essentially like a Koki pen, a felt tip pen. That's what he'll have. Why can't he have the flexi pen instead? So they said, okay, he doesn't have to use the flexi pen. You know, it's a distraction, said the defense. Okay, felt tip pen for you.
Present in front of the jury, the court understands the concerns of the deputies, and I sympathize with that. The layout or the construction of the flex pen is different than the construction of ordinary pens. I fear that it may create a question in the mind of the jury as to his incarcerative status. That would be prejudicial. So he'll be provided with a felt pen, and he'll just leave it on the table. Any further?
Just a logistical matter, Your Honor. We are intending to bring a whiteboard or TV for the presentation of evidence next week, so as to protect as much as we can the sensitive nature of the material that we must show to the jury. So logistically, I just wanted to bring it to the court in defense's attention.
Will this be on a card?
Yes. It's on the list.
So what do you need from me? Place to put it?
We can bring it up when we are intending to use it. I just wanted the court to know because I know sometimes the court is going to need to get down to view the evidence. I anticipate that we'll put it over closer to the jury so that the family who is also potentially going to be present will not have view of it also.
Okay, good idea.
Other individuals.
Understood. Thanks, I understand. Evidence is obviously of a sensitive nature and is unlawful in and of itself. I am happy to provide the courtroom on the afternoon of the 21st if you want to wheel your equipment up or have your tech folks do so. Gameplay how you would like to present that. The attorneys will obviously have an opportunity to move about the courtroom as they need to observe evidence. Mr. Stearns also has a right to view the evidence being considered against him, so we're going to have to accommodate all of those competing interests to ensure that.
No, we don't want that. I understand that in usual circumstances, the defendant would have the right to view the evidence they have against him. But in this case, as someone said earlier, maybe he's taking this to trial so that he can freaking see all the pictures and videos again. One last time. That's sick. I don't think he should be allowed to see that. To see the child essay material that he made. That sucks. Because they're going to put the evidence they just said on like a TV and they show it to the jury and not to the family, and obviously not streaming any of that. We'll have audio. We'll be able to see the courtroom, I would assume, and hear what's going on, but not see that evidence. Why must he see it? I understand. Okay, if someone's going to say because it's the law, I understand that he's a defendant, he's innocent or proven guilty, but holy crap, in this type of circumstance, that really sucks that he's going to be able to. So for anyone who missed, because it's very mumbly, right? The audio is not great and we boosted it. You should hear the original. Oh my word. Okay, he's going to get a felt tip pen. So like a Koki pen, right? He'll get a felt tip pen. He will not have freedom of movement in the courtroom. He's going to have a leg brace. So he suffered lots of losses today. But unfortunately, he's going to be able to see the evidence that they have against him, which is everything from his own collection, his own Google Drive account. That is so infuriating, honestly. I wish I could be there in the courtroom, just glare at him. But don't worry, I'll be here with you. We're going to be virtually in the courtroom, glaring at him either way.
The jury has an opportunity to review the evidence that the state intends to present. Does the state intend to close the courtroom or request a closure of the courtroom during the presentation of any testimony or evidence?
Your Honor, that is the intention of utilizing the whiteboards that only individuals that have to view the content. We do not have a surviving victim to testify in this case, so I don't know that we necessarily have a right to close the courtroom for any of the proceedings. However, due to the sensitive nature of the material that is going to be presented in the form of actual videos and photos and things, the state intends to utilize the whiteboard in an effort to prevent other individuals that do not need to see that evidence.
I anticipated some of the evidence was multimedia, and I didn't know whether it had sound or what the position was going to be.
There are...
Just look at him sitting here. That is the scariest thought, is that he actually might want to go through with this freaking trial so that he can see his own collection just one last time. That is so... I've said it already. Can they please give him that stun cuff and position it appropriately? Could they consider where to position it? Could we maybe vote for where? Because I have a couple of ideas, okay? And just from the FOIA request, just seeing there's no CSAM evidence. There was just him when he was arrested being undressed and seeing how they were looking for the freckle and all that. Oh my word, I feel sorry for the jury. I had to look at that. Oh no. Even just seeing him naked is traumatic, okay? Now you're going to see him in action with a child? No. And he's going to sit there, look at him. He's like, okay, yes, I'm ready for this trial. What is wrong with you? Everything. Everything is the answer, right? That's rhetorical, but this just makes me even more mad. Even more mad. They're almost done with this hearing, by the way.
I believe 5 counts that are video with sound.
If the state makes a determination that closure of the court was warranted pursuant to statute and victim rights, Marcy's law, I'll ask that's your intention. You present that in writing, we'll address that. Give the defense an opportunity to weigh in on that request.
Yes.
Thank you. That's,
I believe those are all the cases.
thank you. But as I said, the court will make itself available for the rest of this week and on Monday for access to the courtroom. If you have specialized concerns, equipment concerns, please be proactive in asking in advance and resolving those issues with court staff prior to jury selection beginning on Tuesday, the 22nd. That'll conclude our hearing. Thank you.
Okay, wait, we'll watch his little exit in a moment here. Sussex Sandra said, this is one trial where I'm not worried about the verdict. The prosecution would have to be complete bozos to lose this trial. Yeah, I'm not worried about the verdict. I'm actually worried that he's taking this to trial because the poor jury has to see those images and videos. And it's just based on all the documents we've read, everything that we've read that they have. Wow, it's really going to be disturbing, right? Joanna Kimball said, this animal makes me physically sick. I wouldn't be able to stomach any of this without UG and the Grizzlies. Justice for Maddie. Yeah, sometimes I also get, if you just think about it, because we're watching all this and, you know, I'm angry about it, but when you just slow down and think about what he's charged with, it makes me nauseous. It makes me so sick. I feel so sorry that Madeline Soto was abused for so long based on the evidence that the state has. Of course, he's innocent or proven guilty, which shouldn't take long. The trial starts with jury selection on July 22nd of 2025. I don't think that'll take long either. Maybe by July 23rd or 4th, we'll have the trial going, and I think it's set to last for about 4 days, if it'll even take that, you know? Oh my goodness. So, yes, you said justice for Maddie. Absolutely. So let's just watch him leave. Are you ready? Here he goes.
Senator, you got to provide the film.
Yes, Judge, we can provide those.
We'll run those, bring them in and let the justice take a look.
It's a court of preference. Blue or black, color preference.
To you guys.
Off he goes.
Yeah, I was going to put it back. Yep.
I need to know what this is and what's going on.
Well, that's the end of the hearing. So thank you so much for watching that with me. I also feel grateful that we can watch this together, because watching this case alone, oh my goodness, it's just so infuriating. It's so sickening to think what Madeline Soto went through. And I mean, she only just turned 13 when she was murdered. And they believe that she was strangled. And they've accused Stephan Stearns of doing that. And to think that he just disposed of her body as well the way that he did, he drove around with her deceased strapped into the passenger side of his dad's vehicle in broad daylight, pretending he's dropping her off at school, drove around with her dead body in the passenger seat for hours, and then went and parked in some vacation headquarter building, and then moved her body, carried her body out from the front, from the passenger seat, put her in the trunk, went back home with her body in the trunk. On February 26th of 2024, went back home to Jennifer Soto's home and hung out with her a little bit, and then factory reset his phone. Twice that day, while her body was in the trunk. The first thing he did was like, all right, we're first just going to stop at the dumpster and throw away her school bag and her Crocs, school laptop, gone. Now we're going to drive around a little bit and talk about McDonald's and cherry Danish pastries. Oh my word. This guy is so sick. It's like, really, I can understand why some cases like this one, he will be facing the death penalty, right? It will be a capital murder case in September. This is now a CSAM, child SA material case. 60 counts of CSAM related charges. Each count is representing 10 or more images and videos. They say they've got 1,700 images and or videos just from his Google account. Now, can you imagine on the hard drives? And there's previous videos that I made for you discussing that there's a hard drive they found in his dad's storeroom that apparently belonged to Stephan Stearns. It was actually a flash drive. And there were 38,000 CSAM pictures on there, not of Madeleine Soto by the sounds of it. Sounds like other collections he had. They haven't even charged him with that yet. I would hope they would. Maybe they feel like maybe they can't prove it's him. Maybe he's not in it. I don't know. But that is so sickening, right? Spacey Dove said justice for Maddie. I really hope so. I think there will be justice for Maddie. I think this guy is so dumb for taking this to trial. But okay, dude, we'll be there watching every second, and we want justice for Madeleine Soto. So yes, I could go on. I could say a lot. I do also want to say that the documents say that Madeleine Soto was strangled and that he disposed of her body. And I've never actually read these documents with us or together. I've read it myself. I've never read it out to you guys. But in the documents, it does say that there was evidence of blood under her fingernails, on her hands, on her neck, and other private parts below the waist, front and back. Blood, evidence of blood. It is, I think that murder trial is going to be even worse, honestly, obviously, because we'll hear even more about that. Yeah. So make sure you are subscribed, because YouTube sometimes has updates. It will unsubscribe you automatically. Make sure you are subscribed with your notifications on. If you want guaranteed notifications, go to Patreon. Okay, you can join the free public tier and you'll get majority, 99% of the notifications, right? The other 1% is when I'm posting something special for all the pledge supporters, and then I just tell them there's a live stream coming up, right? But most of the notifications you'll get over there, because yeah, we're going to be watching this. We've also got Brian Kohberger's sentencing coming up. We'll be watching that together. We've got lots to do. I just want to quickly say at the end here, everybody's asking, am I going to be covering the James Craig trial, the Colorado dentist who allegedly poisoned his wife with cyanide smoothies? I would love to. Apparently, opening statements are due to start tomorrow or the next day. But cameras in the courtroom are only allowed for opening statements, closing arguments, and the verdict. That just makes me so mad. Come on, we want to see everything. So I'll cover what I can, which are those three things. That's all we have, unfortunately. So I will see you again very soon. If you missed the sentencing of Christopher Dontel in the Megan Jackson related trial, Gregory Rice's murder, today, go check out that stream as well. All right, everyone, I'll see you in the next one. In the meantime, stay safe, and yeah, let's all stick together and watch this unfold. Justice for Madeleine Soto. My big question is, will Jen Soto testify? Can't wait to see that.